is presiding, and now ends this session. Please be seated.
Good morning and welcome to the First District Court of Appeals. As you can see, Judge Kinsley will be participating virtually this morning. We have two cases on the docket. When I name your case, if the attorneys or whoever's representing the parties could please rise, tell me your name and your readiness to proceed. The first case is State v. Gribbins.
Good morning, Your Honor. Sarah Nelson, acting as supervising attorney today.
Good morning, Your Honor. My name is Andrea Micheli. I'm a legal justice practitioner on behalf of Mr. Gribbins.
Thank you.
Hi, my name is Dakota Parrish. I'm appearing on behalf of the city of Cincinnati today.
Thank you.
Thank you.
And our second case to be argued this morning is First Financial Bank versus Tailored Fund Cap LLC.
Good morning, Your Honor. Susan Argo, Ricker Graydon, on behalf of First Financial Bank, prepared to proceed.
Good morning, Alex Durst and Paul Carriage of the law firm Durst Carriage for the appellant Tailored Fund Cap, and we are ready to proceed as well.
Okay, thank you. I will be keeping your time. The green light means go. Yellow light means you have about a minute left, and your red light means that your time has expired. Whenever you are ready, you may come up and start. Would you like to reserve any time?
Yes, Your Honor, 3 minutes.
Okay.
Good morning, Your Honor. My name is Andrea Micheli on behalf of Mr. Gribbins under the supervision of Attorney Nelson. This case deals with a sole assignment of error. Mr. Gribbins' constitutional speedy trial rights being violated. This court heavily relies on the factors of Barker v. Wingo, a United States Supreme Court case from 1972 to determine whether Mr. Gribbins' constitutional speedy trial rights have been violated. These factors are the length of delay, the reason of the delay, defense assertion of his right, and presence of prejudice. Now, for the length of delay, here, based on Barker v. Wingo, we look at the peculiar circumstances of each case, and based on also on the Doggett versus United States, another U.S. Supreme Court case from 1991. It depends also on the type of crime to determine whether the length of the delay is prejudicial. Based on the type of crime, we have in this case 2 misdemeanors. We have theft misdemeanors in first degree, and we have a trespass misdemeanor in 4th degree, and we have a length of delay from the moment of the arrest to the moment, from the moment where the charges were filed to the moment of the arrest of 687 days, which is 1 year and 10 months. Therefore, these factors is met because we have already in this court other cases where they found that the length of delay was prejudicial. In State v. Sears was 9 months, State v. Benton was 7 months, and therefore this factor is met. Since this factor is met, this factor triggers the analysis of the remaining factors. The reason of the delay in this case,
Counsel, it seems to me that there are 2 potential reasons for the delay in this case. One being the state's failure to take action on the warrant, and the other being Mr. Gribbins fleeing from the scene when he was apprehended by the store loss prevention officer. How much of the delay in this case should we attribute to Mr. Gribbins, and how much of the delay should we attribute to the state?
That is a good question, Your Honor. If we look at the Doggett case, the U.S. Supreme Court case, here we can clearly see that there is contributory negligence, but still, if we consider the Barker v. Wingo case, they said that the ultimate responsibility of the circumstances rests on the government. So even if there is contributory negligence on behalf of the defendant, still it's the responsibility of the government. And still, we shall consider the negligence of the officer to not serve the defendant. And
Can I ask you, this wasn't clear, or maybe it was and I missed it. How did he ultimately get apprehended? How did they find him?
in another incident that was not related to the incident issue. It was, I think, another theft because my client has an history of other misdemeanors involving theft in mayors, but he was not arrested because of this incident.
Okay, so they didn't finally track him down or something. He was arrested for something else, and they found out that he had a warrant.
Yes.
Okay.
And also, there is no attempt on behalf of the officer to serve the defendant, and the officer, based on his testimony, he did not remember sending anything to Gribbins, did not know Mr. Gribbins was notified of the complaint and warrant, therefore this factor is also met. Then we go into the third factor, which is the defendant assertion of his right, and based on State v. Watson, another case decided in this court, is that the court said when the defendant has filed a motion to dismiss for a speedy trial right, Ohio courts weigh the third factor in defendant's favor. And in this case, he was arrested. My client was arrested on November 18, 2023, and he filed the motion to dismiss for a speedy trial issue on November 27. This is 9 days, less than 10 days. Therefore, this factor is met. Now, the most important critical factor for this case is presence of prejudice. Now, based on the Barker v. Wingo and the Doggett case, it is extremely hard to prove actual prejudice. But still, in the Doggett case, that was a case decided based on presumed prejudice.
That was 8.5 years, right?
Right.
Okay, so we have 2 years here.
And
that was
how are we to weigh the fact that the store, in this case, the victim of the theft, kept the video and that was still there for the trial?
Your Honor, that is a good question, but that goes to the issue whether the state can prove its case. It does not go to the issue whether there is prejudice to the defendant, to my client.
That goes to actual prejudice, right?
Yeah, actual
So
prejudice because
there's no actual prejudice because the video was kept, and right?
yes, we have stipulation that there is the video, presence of the video. We do not have stipulation regarding the content of the video. So this goes to the factors of prejudice, which are we have oppressive pretrial incarceration, anxiety or concern on behalf of the defendant, and in this case, we do not have the first two factors, but we do have the third factor, which is the ability of the defendant's defense will be impaired by demeaning memories and exculpatory evidence.
Was there any evidence before the trial court that would show that the defendant didn't remember what happened, or that the delay actually, or that the delay might have caused prejudice?
Yes, we do have evidence that based on faded memories, we have the officer, he did not remember sending anything to Gribbins, and we have, that is negligence, and we have state research that was where they found prejudice because of negligence on behalf of the officer, where he did not remember whether he whether he served the defendant, and plus they the officer do have the address where to locate the defendant, but did not make any attempt to ensure that he was served. And that is
But
negligence.
doesn't the officer's lack of memory as to whether or not efforts were taken to serve Gribbins, doesn't that benefit Mr. Gribbins and harm the state? Because that shows that the state did not take efforts under the second factor to shorten the delay, right? So that really undercuts prejudice to the extent that it benefits Gribbins rather than harms him.
Yes, Your Honor, that's correct. But still, we are relying on based on precedents and how they determine whether there is prejudice. And in state research, they talk about whether if the officer knows the address of the defendant but does not make any attempt to locate where the defendant is, then we have prejudice in that case.
It seems like what you're asking us to do, because I don't see that you've shown actual prejudice here. You're wanting us to presume prejudice. And you want us to presume prejudice basically to punish the state for the delay, right?
Absolutely.
That's what you're asking us to do.
Yes, because in the Doggett case, the court ruled in favor of the defendant without the need to go into the discussion whether there is actual prejudice, because the lengthy lag between the time of the arrest, between the time the charges were filed and the arrest is sufficient to have prejudice. We do not need to go into the discussion of whether there is actual prejudice, but we still consider if there is presumed prejudice, we still have to weigh that factor together with all of the other factors. And we have all the other factors.
But where do we draw the line regarding the amount of time that has passed? Because you keep referring to the Doggett case, and that was a felony charge or felony drug charges, and it was 8.5 years where the government, according to the court, didn't do anything to try to find him. So where do we draw the line when it comes to a misdemeanor case like this?
In that case, they talk about, in State v. Benton, State versus Sayre, they talk about if it is a misdemeanor, there must be an extraordinary delay. They talk if it is a street crime, ordinary street crime, then the length of delay is definitely less than what there could be in a felony case to be considered sufficiently prejudicial. So in this case, we have a misdemeanor in first degree and misdemeanor in fourth degree, and so if in the Doggett case was 8.5 years, because here we have precedents where they consider misdemeanors, like in State versus Sayers, it was 9 months. Here we have 1 year and 10 months, so 687 days. Therefore, definitely it's the length of delay, the type of crime, and also whether the defendant was aware of the charges being filed against him. And in this case, we do not know, we do not have evidence that the defendant knew of the charges filed against him.
He ran. They tried to stop him and he ran away.
He ran from the incident. He
Right.
did not run from the police. He did not run from the service.
Can't we
And-
presume that he would figure that they were going to file charges against him when they tried to stop him from running from the store?
It's not about whether charges have been filed, but what charges have been filed. That is mostly important. Here we have 2 charges. We have theft in first degree, misdemeanor in first degree, and trespass in fourth degree. And in Latin, they say scripta manet verba volant, and which means if I don't see it written, I don't know what I'm going to have, like what charges have been filed against myself. And in this case, still, we cannot say there is no prejudice because he probably would know that charges would be filed against him because we do not know, the defendant did not know what charges were filed against him. And he did not flee from the police, from the service to be served. He flee from the incident, and plus, when he flee from the incident, he left the merchandise stolen there. So mayors could retrieve the merchandise.
Mr. Michelle, if you want to reserve time, you're kind
Yes,
of tired.
I would briefly, if I may, I would like to briefly conclude. Reserve. Okay. Therefore, we respectfully ask this court to find, to reverse the lower court decision and to find that my client's constitutional speedy trial rights have been violated. Thank you.
Thank you. Whenever you're ready.
Thank you. Good morning. On behalf of the City of Cincinnati, my name is Dakota Parrish. I'm going to ask that you affirm the trial court's decision in denying the motion to dismiss. So a criminal defendant's right to speedy trial is guaranteed by the Sixth Amendment of the United States, as well as Article 1, Section 10 of the Ohio Constitution. The right of the speedy trial is triggered by the arrest, indictment, or other official accusation, and I pulled that from Doggett versus United States. In determining whether a defendant's speedy trial, or a defendant has been deprived of his constitutional rights to speedy trial, the courts employ the, it's commonly referred to as the Barker four-factor test, the length of delay, the reason for the delay, defendant's assertion of the speedy trial right, and the prejudice to the defendant. Starting with the first factor, the length of delay operates as a triggering mechanism. The length of delay inquiry serves as a threshold inquiry that the defendant must satisfy before triggering further analysis under the Barker factors. In determining an unconstitutional delay in prosecution, the question should be whether the delay causes constitutional concern or is sufficiently prejudicial to warrant further review of the speedy trial claim, and I pulled that from State v. Benton. The Ohio Supreme Court.
Counsel, same question to you. So how much of the delay in this case is attributable to the state and its failure to serve the warrant, and how much of the delay is attributable to Gribbins and him fleeing the store?
So in this, I would argue that both parties are at least equally at fault in this. So Gribbins, the record that we have from the motion to dismiss hearing is from Tyler Vest, the asset protection manager. He testified that he knew that Gribbins had numerous warrants for similar kind of behavior. He fled the scene. He also testified that Gribbins had been trespassed less than a month prior from all Meyer locations, and he had the paperwork available to him at that point, or at the motion to dismiss setting. So the state would argue that Gribbins did flee the scene because he knew that he was going to be prosecuted for not only the theft, but also everything that he had for the outstanding warrants, which were testified to, as well as for the trespasses. He would have had knowledge that he had been trespassed from Meyer stores.
But, so they knew who he was?
Yes.
Does that cut against the state, the fact that they knew exactly who he was?
Well, and I would agree that there is fault on the state as well, and I believe that as far as getting into the reason of the delay, the testimony that was elicited at that motion to dismiss hearing was somewhat, I think, lacking, but the officer did testify that he couldn't recall any specific things that he had done. He had also testified that if anything was sent out to him, it would have come from a different unit, and there was nothing presented into the record that anything at that point had been sent out. So
the record as we have it is that the state didn't do anything?
correct.
Okay.
The officer conducted an investigation at the scene. Gribbins had fled the scene at that point, and he couldn't recall anything further he had done at that point. And I would argue that if we're getting into the reason for delay factor, the courts have found that there's two different reasons for a delay. There's deliberate attempts of the state to cause a delay in the defense's case, and I think that, and then there's also a more neutral reason, which is negligence or overcrowded courts. And reading from Barker, a deliberate attempt to delay the prosecution of a case should be weighed heavily against the state, whereas negligence should be weighed less heavily, but nevertheless should be considered. I think in this case, there was nothing that was put into the record at the motion to dismiss hearing that the state did anything to deliberately try to thwart Mr. Gribbins' attempt, constitutional rights to a speedy trial or hamper in his defense whatsoever. The testimony that was elicited was the officer showed up to the Meyer location after the offense occurred, and once he got there, Gribbins was no longer on the scene. He conducted his investigation, and then for one reason or another, nothing that was testified to, he did nothing further at that point. And so I believe that that is similar to the case of State v. Mugney, where this court found that when the police made no effort to track down the defendant, citing the officer's general city busy schedule, there was no indication that the state deliberately delayed prosecution, which constituted negligence. Which did constitute negligence and weighed against the state, albeit not heavily. So I would ask this court, considering the factors put into the record at the motion to dismiss hearing, that while I do believe that there was negligence on behalf of the state and the officer, Butler, for not doing more follow-up investigation, to weigh this against the state, but not heavily, because there was no evidence put in or no testimony elicited during the motion to dismiss hearing that the state did anything to try to thwart his efforts to defend his case or to intentionally hamper. It was negligent at best.
Were other cases that ended up finding a speedy trial violation, or did the court find in those cases that the state actually intended to hamper the defense in some way?
I'm not sure which case you might be referring to.
I'm just asking you if, when a court determines that there is a speedy trial, a constitutional speedy trial violation, in those cases, do they find that the state acted intentionally or negligently, typically?
I can't speak as to all the cases. So my answer would be somewhat incomplete, and I don't want to say anything without having done a full.
I mean, are you
into it,
aware of
but,
a case where the court found a speedy trial violation, and in part because it found that the state acted intentionally?
I have not read one.
Okay.
I'm not saying that one does not exist, but I have not read one at this point. The state is also not, we're not trying to dispute that Gribbins and, sorry, I'm just getting back on track, that he didn't assert his right to the speedy trial on time. I think that he did timely do that once he was arraigned, and then we had the setting filed shortly after for the motion to dismiss. But the main point that the state wants to make is we don't believe that there has been prejudice to Mr. Gribbins in this case. Prejudice to the defense is the most serious interest protected by the speedy trial right, yet is often the most difficult to prove. And the Barker court found that prejudice should be assessed in light of the interests of the defendant and identified 3 interests to consider. I think one of them is relevant to this, but I'll read all 3. The first is the prevention of oppressive pretrial incarceration. The second is minimizing anxiety or concern of the accused. And the third is limiting the possibility that the defense will be impaired. So as to the first 2, just briefly, I don't believe that there was anything put into the record that there was lengthy or oppressive pretrial incarceration, nor that there was anxiety or concerns on the part of Mr. Gribbins.
Would Mr. Gribbins have known that that there was a warrant out?
What is in the record is that there were warrants out. I don't think that anybody addressed whether he would have known that there were warrants out. I think that there could be a presumption made that if he knew that he had been trespassed from Meijer just a few weeks prior, was caught inside of a Meijer store just within the same month that he had just been trespassed, that new warrants would potentially be going out for his arrest. I believe that the testimony that was elicited at the motion to dismiss hearing was that the warrants were for similar offenses and that he was well known throughout Meijer stores. So I think that there is a strong likelihood that he should have known.
So can we infer that there was some anxiety or concern?
I would argue that if there was anxiety or concern about dealing with criminal charges, he could have turned himself in on those warrants at a sooner time. The fact that he waited until he was arrested on another later theft case, I would think would show that there was no anxiety or concern on his part, especially if he had been found at a later date committing similar offenses. I don't know if that would show that the defendant necessarily had any anxiety or concern about past thefts if he had been caught doing more thefts in the future.
Thank you.
And also, I would just note that there was no testimony put into the record at any point that he had any anxiety or concerns related to these charges. I believe that he opted not to testify at all, or on the advice of counsel did not testify at all. But as for the final factor, I believe that first, there is no actual prejudice in this case. The state preserved the video recordings of the alleged incident. What was stipulated to during the motion to dismiss hearing was that there was a video of the event or of the alleged incidents, and it was stipulated that it did exist. The only thing that was not stipulated to was the identity of the subject of the video. However, Tyler Vest, during the motion to dismiss hearing, was able to identify Gene Gribbins as the offender for this alleged incident. So I believe that in the totality, we're able to show that the state preserved, through Meijer, the video of the incident. The state also provided both Tyler Vest as a witness who was available to testify, and also the officer in the case. And while the officer did not necessarily remember a whole lot about this incident, he showed up after the fact. He didn't see the incident. He showed up after the fact. And I think that can explain his lack of knowledge to the particulars of the case. He just knew that he was there. He filed citations, and I believe that was essentially the extent of what he testified to as his involvement in the case, other than not following up further. I do think that notably the defendant never raised the issue that there was other witnesses who were unavailable that may have assisted in his defense during the hearing.
Counsel, who would those witnesses be? I mean, this idea of presumptive prejudice, I think, calls us to speculate as to what kind of defense Gribbins could have put on, but was prevented from doing so because of delay. And I'm struggling in the context of this particular case to understand what that might have been, given that the incident was caught on surveillance camera, the loss prevention officer was able to describe with particularity exactly what occurred. I mean, what sort of other defense or witnesses or evidence might Gribbins have been able to come up with had the state acted more swiftly in bringing him to trial?
I would argue, I mean, based off of my knowledge of this case, as well as any knowledge of prosecuting previous theft cases, I'm not sure what other kind of evidence Gribbins may have chosen to put on. I understand also there may be strategies as to different kinds of defenses. The first one that can come to mind, really the only one, would be any alibi defense that could have been put on, namely, it wasn't me kind of argument. But there's no evidence that anything like that was put on. An identity was testified to by Tyler Vest. However, I do believe that on that topic, the fact that the state preserved video surveillance showing the alleged incident cuts both ways, because hypothetically, if this was not Mr. Gribbins within the video and alibi was a defense that was raised, the video would clearly show the finder of fact one way or another who was in the video, and identifying factors from the subject of the video could actually help Mr. Gribbins in that incident if that was a defense that would have been raised. But to kind of conclude my answer to you, I'm not sure what defenses would have been raised when you have a video surveillance showing the entire incident. At that point, I believe it's up to the fact finder to make a determination that any and all of the elements are presented to the court at that time by the state, and see if they are able to prove that beyond a reasonable doubt. But I see my wrap-up button here, so I'll just leave on this. I'm asking this court to overrule Gribbins' first assignment of error, sole assignment and error on this case, and to affirm the judge's determination during the motion to dismiss hearing that due to the fact that there really was no prejudice in this case, a motion to dismiss was not an appropriate remedy at that time.
Thank you.
Thank you.
Mr. Michelli, you have about 2 minutes.
Back to your question, whether there is a case of whether the officer intentionally did not serve my client, the defendant. Well, we do not need to go into that discussion, whether intentionally, because negligence is sufficient to trigger to determine whether there is prejudice. And we have, for example, the Magny case, where the officer knew where the defendant was located and did not make any attempts to serve the defendant, and so we do not need to go into the discussion whether there is intent. Regarding the fourth factor, presumed prejudice, specifically about identity issue, we have stipulation of the presence of the video, but we do not have stipulation of the content of the video. Therefore, it's still we have the mayor's the store manager who stipulated that he identified in open court the defendant, Mr. Gribbins, but still 1 year and 10 months have elapsed from when the incident occurred, and plus he did not even make any sworn statements regarding the particular characteristics of the defendant at that moment when he identified the defendant. We only have stipulation of the presence of a video, but still that leads to an alibi defense.
Mr. Michelli, your time has expired. I'll give you 30 seconds to wrap up.
Thank you. Therefore, we respectfully request this court to reverse the lower court decision and to find that Mr. Gribbins' constitutional speedy trial rights have been violated. Thank you.
Okay, thank you. Your case has now been submitted, and we will issue a timely decision.
Thank you.
Thank you. Nice job, Mr. Michelli.
Scranton, New York, when traveling back to Cincinnati over the weekend due to the software glitch and all the delays.
Whenever you're ready, Mr. Durst. Would you like to reserve time?
Yes, I will reserve 5 minutes for rebuttal. May it please the court. First Financial Bank did not meet its burden to prove that Tailored Fund Cap LLC committed conversion for 5 chief reasons. First, FFB did not meet its burden to prove that Tailored Fund had a security interest in the relevant company's accounts receivable, and therefore Tailored Fund cannot have converted, a non-existent security interest. Second, Chapter 1309.332B of the Ohio Revised Code, regardless of whether there was a security interest, provides that funds transferred from a deposit account are taken free and clear of a security interest, which precludes conversion. Third, again, putting aside the security interest issue and the 1309.332B issue, Shining Knight and the Wexford companies, the relevant SOSNA entities, were expressly allowed under the loan documents to sell their assets, including their accounts receivable. Fourth, turning to damages, First Financial plainly did not satisfy the tracing statute or even their own stated theory of damages to prove that my client, Tailored Fund, was paid with proceeds of anything, i.e. accounts receivable, that First Financial Bank had a security interest in by their own very plain admissions at trial. And last—
Counsel, by my count, FFB has pursued 3 different damages theories in this case. The first one in the complaint sought recovery of the converted funds. The second one in the default judgment motion sought the loan balance at the time. And the third one in the summary judgment motion sought $3 million, the sale price. Which one of those controls the damages calculation in this case, or does something else control?
Well, so I'm going by what First Financial argues in its appellate brief, which is that what was converted allegedly was accounts receivable on the day the 2 merchant cash advance agreements were signed, March 23rd, 2020, before any money changed hands. And that, the damages, they claim, were all the funds that were transferred to Tailored Fund. And so in the cross-examination of Tracy Farrell and in the discovery responses of First Financial Bank, when we asked them what their damages were, they were very clear that they were drawing a connection between the funds paid to Tailored Fund and the accounts receivable that were purchased. Now, the problem with that, under any theory of conversion, there would have to be, well, let me back up for a second. First Financial Bank cannot make a claim against Tailored Fund for conversion simply of the funds that they received from the deposit account, because really it's not possible to convert money. If it's coins in a bag or like some specific money, then there are some limited exceptions, but generally money in a deposit account that's been commingled with other funds is not sufficiently identifiable. It's just black letter law that can't be conversion. And we cited a lot of case law to that effect in the initial summary judgment briefing. And in fact, First Financial Bank made that same argument in another case when S&T Bank sued First Financial Bank for conversion. Okay. What First Financial Bank claims is that what was converted was the accounts receivable, but it's clear that putting pen to paper on the 2 MCA agreements or factoring agreements, whatever you want to call them, that did not cause a financial loss to the bank. And in fact, at that time, the Shining Knight and Wexford were current on their loan obligations. So what I agree, the theories have shifted. I mean, there are so many reasons why there is no liability for conversion, but putting that,
Is it possible, counsel, that the theory has shifted because of 332B?
you would have to ask First Financial that. I mean, if you look at the complaint and what's alleged in the complaint, and as Your Honor aptly pointed out in the motion for default judgment, initially it appeared as though the claim was just for the funds taken from the deposit account. And then after we filed our initial memorandum in response to First Financial Bank's motion for summary judgment, that was when, I mean, there was somewhere in the filings where First Financial Bank argued that their quote-unquote primary argument was that it was the accounts receivable that were converted, not the funds. And then at the damages trial and at later stages of the case and on appeal, my understanding is First Financial Bank is saying the accounts receivable are what was converted. Not any that are identified, but some unspecified, unidentified accounts receivable of Shining Knight or the Wexford companies. And they were Tracy Farrell's testimony was very clear. She acknowledged when reviewing First Financial Bank's discovery responses, they're saying what was converted was on March 23rd, 2020, when pen was put to paper on the factoring agreements. And then when we asked in discovery what are FFB's damages, they state all funds transferred to Tailored Fund from the bank account that we refer to as the 7599 bank account.
And you're saying that those funds, some of those funds also belong to other companies that your client entered into agreements with?
So that is likely the case. It's First Financial Bank's burden to trace. So to back up just a millimeter, as evidenced by the merchant cash advance agreements, Tailored Fund purchased accounts receivable of 18 different entities: Shining Knight, Wexford Place, Wexford Care Center, and then 15 other entities such as Pleasant Ridge Care Center that First Financial had no relationship with. They didn't have a security interest in their accounts receivable.
It all went into the one account.
That's correct.
All of the money went into the one account and was paid to your client from that one account.
That's correct. And so, so basically, I mean, the case law on tracing is very clear. What First Financial Bank argued at trial was they said, we traced the funds right out of the 7599 account to Tailored Fund. Okay, but tracing has several prior basic steps where First Financial Bank never met their burden to prove that Shining Knight, for example, ever deposited 1 cent of anything, much less the 1 cent of proceeds of accounts receivable, into the 7599 account. Or even really that Wexford did. I mean, the account was held in Wexford's name, but if you look at the account statements, it's, hundreds of millions of dollars are going through the account. First Financial Bank never proved that Wexford or Shining Knight deposited 1 cent into that account. And when I cross-examined the First Financial's Vice President Tracy Farrell with the discovery requests, I asked her, like, okay, so you're saying there's a connection between the accounts receivable that were purchased from just Wexford and Shining Knight as opposed to these 15 other companies that there couldn't even conceivably be anything wrongful as to FFB of Tailored Fund purchasing. You're saying that those accounts receivable, there's a nexus, there's a connection between those specific accounts receivable and all the funds that were paid to Tailored Fund from the 7599 account. She said yes, like that was their theory. And it's only logical too, because if Tailored Fund is paid with just random funds in a bank account, then that's not wrongful as to First Financial. There's no way that it could be unless they met their burden to prove they had some kind of interest in those funds, i.e. by proving that those funds were proceeds of accounts receivable of Shining Knight or Wexford.
Well, that's why, so their theory has to be the conversion didn't occur at the time of the payment. The conversion occurred when the agreement was entered into.
That is my understanding of their position.
Okay.
So my understanding is that their position is conversion happened on March 23rd, 2020, when the agreements were signed.
You have 5 minutes
Counsel,
left, but I'm not going to count this against
Can you
you.
address the 332B issue and why we should not follow the Tusa Expo case?
Okay, I'm going to keep going, and then if I have time left, I'll reserve it for rebuttal. First of all, if you look at the Tusa case that First Financial cites vehemently, Tusa talks about a secured creditor being required to trace proceeds of accounts receivable in a conversion action. It's later on in the opinion. Now, it was in the bankruptcy context, so the burden was kind of reversed just because of the way that bankruptcy cases work. But Tusa stands for that additional proposition. Okay, in terms of Tusa versus Cortland, the problem with Tusa, as explained in Cortland, is that the Tusa court ignored the definition of account and decided Tusa on the mistaken understanding that a deposit account actually contains funds, as opposed to simply being basically a promise by the bank to pay the holder of the account the amount of money that's in the account. And also Tusa, if you read it, it involved this kind of intricate business arrangement where funds were deposited into a lockbox and then into another lockbox, like physical cash. So perhaps in the Tusa context, saying that an account, because I suppose, my understanding is it was argued that, that was an account, the lockbox with the funds in it. Like, if you want to say that an account contains funds, that makes more sense in the context of a lockbox containing money in it than it does in a bank
Tusa,
account.
there was a subordination agreement as to who would take first and second priority between the creditors, right? And then the court interpreted 332B in accordance with that subordination agreement. But we don't have a subordination agreement here. The two of you are fighting as to who gets first priority. So should the existence of that subordination agreement in Tusa play any role in how we read that case?
Well, it's a distinguishing factor. I mean, I would say tailored fund does not have the burden to prove that we have a superior position. First Financial had to prove that we committed conversion, and because the security interest was stripped when the funds were transferred, in addition to all the other reasons why there could not be liability for conversion, that it just precludes a conversion claim. And that's what Judge Barrett has found. It's what every other Hamilton County judge has found. We cited a number of cases from around the country, some actually citing Cortland. The Tusa case is an outlier, and I think that it has some real distinguishing facts. Unless there are more questions at this juncture, I'll reserve however many seconds I've got left for rebuttal.
Thank you.
Thank you.
Good morning, Your Honors. Susan Argo on behalf of First Financial Bank. I'd like to just start off by noting that we're not here about a dispute between two secured creditors. I'm very perplexed by all of the hypotheticals that have been posed in the brief by appellant, citing, we made a loan. No, they're standing here as a purchaser, and they purchased the receivables subject to First Financial's security agreement. I would also submit that the security agreement, it's a red herring argument to be pointing to Shining Knight. The court, in the bottom of page 2 of the decision, properly says that Wexford Care and Wexford Place granted a security agreement. That security agreement covers accounts, all money on deposit, healthcare insurance receivables, and that is expressly a defined term under 1309-102B. And so it's important for this court to realize that these were nursing homes, and that's the sole source of revenue for these businesses. He was running nursing homes, and so healthcare receivables is what funded the business, what was underwritten on the loan, and was what is First Financial Bank's collateral. So the suggestion that we don't have a security agreement in the accounts receivable is just flat out wrong. They never even reference.
Counsel, even if we agree with you, what do we do with the 332B issue in this case?
Yes, thank you, Your Honor. So here's what counsel constantly says. One, as to TUSA, here's what I would suggest to you. In TUSA, it was two creditors. This is a purchaser, all right? And the reasoning in TUSA is this, that the burden should be placed on a buyer to make sure that they're purchasing assets free and clear of liens. And it's not a heavy burden. Run a UCC search. Check to see if there are other secured creditors. What Tailored Fund did is admit that they never did that. They want ignorance to be bliss. They want to ignore the rights of First Financial.
From a policy perspective, I understand what you're saying, but can you address the language of 332B? Because the drafters of that statute have already made a policy determination that might be inconsistent with the policy that you're expressing.
Yes, so if you look at 1309-332B, if you look at A, it says a transfer of money takes free of a security interest, any security interest. If you look at B, which they are relying on, it says a transferee of funds from the deposit account take the funds, and this is very, very important, free of a security interest in the deposit account. It does not strip any other liens. It strips the lien in the deposit account. So First Financial Bank was perfected in two ways. First, by filing its UCC1 financing statement, and therefore it's perfected in the accounts receivable. At the minute they sold that AR, that accounts receivable was converted. This provision does not strip any lien. It only strips a lien in the deposit account. Then I would say Cortland goes on, and I would note for this court that Cortland was appealed to the Supreme Court, and the Supreme Court accepted cert, seeing the errors of Cortland. Unfortunately, that case was settled. But clearly, Cortland is an outlier, and it's not binding on this court. Because what Cortland said...
Well, counsel, it's not an outlier to the extent that its reasoning was adopted by the federal district court here in the Southern District, and numerous other courts around the country have adopted its same holding, including Key Bank, a case that neither of you cited, but it goes into great detail about why 332B was imported into the UCC, the legislative history of Comment 2, and it really sets a foundation for this whole issue. So it's really TUSA that's the outlier, and its predecessor. There's two cases from Texas that go the TUSA direction, and then every other case goes the Portland direction. So what are we to do with that? We've got this split of authority with what I would characterize as a majority going Cortland's way and a minority going TUSA's way. Help me understand why we should go the TUSA direction.
Thank you, Your Honor. Yes, and the reason being is that in Cortland as well, I mean, I would like to back up and say Judge Barrett did remand, and actually we filed an amended complaint and we got into conversion, so like, it's not just, there is the question of collusion and the like, but the policy here is that TUSA, and all of these cases are different as to secured creditors. This is a purchaser. They're standing here as a purchaser claiming that they purchased AR. And then Cortland goes on to say, what is a deposit account? All right? A deposit account is a right of payment from the bank. And then if you look at the definitional section under 1309-102, account does not include deposit account, all right? Account does include healthcare receivables, and then a deposit account is a right of payment from the bank. A right of payment is a receivable. So if you think about it, the receivable, so when the party, Wexford, deposits money, it has a right to demand payment, in this case, from the depository bank, First Financial Bank. That's a right to payment. That's an AR. I mean, so it comes in. That's why banks have absolute sacred right of set-off. And so Cortland says it's a right of payment from the bank and then says it's not AR. What Cortland does is it makes a leap in logic in saying that this right to payment, and then it relies on language in this B that says, oh, I'm stripping the security agreement in the deposit account. It doesn't say it's stripping the lien of the account receivable. And what I would also suggest is that when they say—
Counsel, as I interpret that, and I admit Cortland is a dense and difficult case to get through, and I've read it many times to try to come to an understanding of what it's saying. As I read that language in Cortland, what I believe it's trying to communicate to us is that having a security interest in a deposit account is coterminous with having a security interest in the funds in the account for precisely the reason you've identified. That putting money into a deposit account is basically creating a promise that you can get the money back out. And so there wouldn't be a such thing as a security interest in a deposit account without having a security interest in that promise that you can get the money back. Is that making sense?
Your Honor, I'm following to some extent, and I do apologize, but no, trust me, I acknowledge absolutely that Cortland is very fact-intensive. You have to sit, read the code, read the case, and keep going back. But I would suggest that what is, troubling here as well is who is tailored fund and the policy purpose. So I would like to get to that. The policy purpose is the free flow of funds. And so, for example, when Wexford paid its employees, those employees should not be afraid of First Financial coming back and saying, oh, that's our money. The landlord or other, those people in the free flow of funds and finality, they should be able to take that money and be paid and not be subject to those type of claims. This is not—
And why is that? How do we know that from 332B? What in the language of 332B distinguishes what we'll call innocent transferees, the landlord, the employees, from TFC?
Because it's done in the ordinary course of business. That's what, First Financial understands, that the healthcare receivables are going to come in, are going to generate it, and that they have ordinary business expenses. It does not state that they get to go off and take— what was going on in the backdrop of this, Your Honor, is a $58 million check kiting. S&T Bank lost $58 million. And so, there is this churn of money coming through. It did not envision Harold Sosna going out and taking loans and selling receivables at 60 cents on the dollar and, just, giving it away. They buried him. That's what caught him eventually.
Isn't that what the collusion exception is for in 332B? But that wasn't pled in this case. So isn't collusion, from a legal standpoint, what might distinguish employees, the landlord, the electric company, from TFC in theory, but it wasn't pled here?
Well, it wasn't— we pled conversion, and then, an affirmative defense is this 1330, so when you look at this, that's the next point that I wanted to make. Look at what they're saying. They're saying, we bought the receivables of 18 different companies, all right? Those contracts are a sham. They identify a purchase price. They never pay the purchase price. They get that ACH authorization.
But there were no allegations. It sounds like you're alleging fraud right now. But there were no, in this particular case, there were no allegations in the complaint of fraud, correct?
not in the complaint of fraud, but at trial, we went into this in great detail. We went into 30 days of transfers where they were just pulling money in violation of their contract. They're standing here waiving this contract as a purchaser to you all. And so let's look at that contract. They're a purchaser of 18 companies' various receivables. They want to poke at First Financial and say that we can't trace. How do they know that they took what they purchased? Essentially, they pulled everything out of that 7599 account. How do we know that the other 15 entities, they purchased those receivables? Why didn't they go get the money from them? You know, that's what is going on here. So then they didn't pay the purchase price. They take the ACH. They were withdrawing money before they ever paid a dime. The contract, you know, like there was no exchange or consideration. They just required Harold Sosna to give that ACH form, and on 30 different days, their contract says the maximum that you can pull is X amount of dollars. 30 days, they're just siphoning and debiting and running that money out of that account. And so when you're sitting here looking at the policy and the concepts of this, that's a sham contract. They're standing here and wanting, yeah.
It seems to me like part of what you're arguing is, and that's, whether we like it or not, MCAs are legal. And that's often the way that they do their business. So how is this different than any other case?
Well, Your Honor, I guess I'd direct you to the attorney generals in New York and New Jersey where all these folks
I'm talking about
shut down. And then in this case, it's not, they're the purchaser. The burden lies with them, is what Avnet, is what, you know, all of these cases. We have, you know, the Southern District of Ohio weighing in. We have bankruptcy courts weighing in. That Avnet case is directly these facts. And yes, there was a subordination agreement in the end, but that was as between two creditors. And so here, it's not that, you know, that they're illegal, but they're using this as a weapon. And then there's no accountability for them. So because they got an ACH authorization, how is it that they're going to stand before you and suggest that they actually took the stream of payments that they purchased? You don't have to get to court, Lynn. You can look at their sham contract and say you didn't follow it in the least bit, and that's all in the record, and that is argued extensively in our briefing.
How does that factor into any element of conversion? So which element of the tort that you sued on does that fact connect to?
That fact connects to, you know, well, let me just get the elements here. It is, you know, defendant's exercise of dominion or control. They got that ACH form and just started siphoning it off before they ever even paid a penny. You know, over plaintiff's property, we've clearly established that we have a security agreement in the accounts receivable, and we did at the time a deposit account. And then in a manner inconsistent with our rights. The whole point that we're saying here, and that's where when you get to the damages portion of this, and you know, they make these arguments that we have multiple judgments. First Financial Bank is not looking to be paid more than what is owed on the loan, and that's been a windfall even for Tailored Fund. So we were able to show the $3.6 million that were just these ACH debits pulled out of that account. They paid 2.6, and then they have never, and like we're one of the 18. Why weren't they debiting from those other folks? You know, they get away with the fact they were like, oh, we just believed Harold was putting all of the funds from his other companies in there. When is there any accountability under that contract to them? You know, it's extraordinary the way that it's structured. And then they say, haha, we pulled it out and it's free of your security agreement. This policy consideration under the code is not to protect buyers. I mean, you know, it's as if they, you know, bought, you know, Jim's receivables and they're just pulling everything from my account. You know, like there's no form or any formality in which they followed the, you know, followed their own contract. They're standing here as a purchaser and they can't show that they followed it at all. And then, you know, as to our damages, I would say that the First District Court of Appeals, we cited that properly And it is important under the code. We have the Monopolis case where there has to be a nexus for damages. And then as to this tracing element, what's very important as far as that goes is that there's equitable considerations. So to my point of when they require commingling, for them to argue, oh, we've required commingling, it made it difficult for you. There are several ways in which, the bank can deal with that. There's the lower intermediate balance rule. You had asked about all of those. We showed
Counsel, the damages equation or calculation has changed 3 times in this case. FFB initially sought the amount of the withdrawals, and then next sought the amount of the loan balance, and then finally settled at the damages hearing on the purchase price. Which of those should it be, or should it be something else? What is the actual damages calculation in this case?
Yeah, and Your Honor, the reason why it changed over time is because First Financial Bank recovered other dollars elsewhere, and we're not trying to recover more than we are owed. But the Monopolis case says, an award of damages must be shown with a reasonable degree of certainty in some manner other than mere speculation. And then it says the damages in a conversion action is the harm done to the market to the measure of recovery of which plaintiff would have to replace the lien. And so if you look at it, this is why it's somewhat of a sliding scale, in that it was 3.6, and we were, First Financial Bank was owed more than 3.6 when we filed the complaint. And then it got paid down, and we're not looking for a windfall. That's to the benefit of tailored fund. But, then when you look, tailored fund, and this reference to the market is what someone's willing to pay for it. And at that time, you have no better snapshot in light of the Monopolis, case in the first district of what price they put on it, is the $3 million. But even at that point, when we were arguing the $3 million, we still never asked for more than what the bank was owed. So, you cite to the $3 million, but we requested $2.6 million. And, the judge said we were only entitled to our principal balance, not interest and fees. But, there is, the nexus, and we've proven the damages. I mean, we watch them just siphon out $3.6 million. And they don't have the right to take, $3.6 million from Wexford. They don't have that right.
Ms. Argo, your time has
Okay.
expired. If you would like to wrap up.
Okay. For this reason, we would ask that the court, affirm the lower court's decision, including the damages amount that was given. Thank you, Your Honors.
Mr. Durst, I gave her an extra 3.5 minutes, so I'm going to credit that to you. You get 5 minutes.
Thank you. Okay, the burden, I want to be very clear, the burden is on First Financial to prove that Tailored Fund converted something that belonged to the bank or something that was proceeds of accounts receivable that the bank had a security interest in. Okay, all these arguments about it's a sham contract, no accountability, they didn't follow the contract, I don't think that was proven at trial. But putting that aside, First Financial made this argument at trial and other similar arguments, like what right does Tailored Fund have to keep this money? Well, the question is whether Tailored Fund converted something that First Financial Bank had a security interest in. If it was a sham contract, what would that mean? It would mean, I suppose, that it's a loan in disguise. Okay, we loaned money to the 18 different SOSN entities and they paid us back. What would prevent us from loaning them money? There may be usury issues in theory, but putting that aside, how would that be wrongful to First Financial? Also, I think it's worth noting, Harold Sosna dealt with Tailored Fund through an attorney. I mean, he was represented, he was a sophisticated party. So if it's a sham contract, then that would mean we just got paid with random funds whatever funds Sosna chose to pay us with. It is First Financial Bank's burden to prove that it's their burden to trace under the statute. They have to trace under one of the 3 acceptable tracing methods under Ohio law. They did not do that. In the opening statement, First Financial Bank appeared to argue that they shouldn't have to trace, that it's ridiculous that they should have to trace because the contracts required commingling. Regarding the MCA agreements required commingling, okay, they require all the receivables from all 18 companies, which we don't know.
Counsel, from reading the other 332B cases, it appears that this commingling phenomenon is an industry standard for MCAs. It looks like from the facts in those other cases that MCA agreements often require an entity and an MCA agreement to put all of the funds in one place so that the MCA company can debit it out from just one account. Is that your understanding as well?
Yeah, that's absolutely correct. Sometimes if it's a merchant that is processing credit card transactions, then the money comes from the credit card processing company where it's held. But absent that, yes, that's the typical practice. And okay, these agreements, they didn't require Sosna to commingle the funds, the receipts of the 18 different entities with other funds. I mean, it required them to put them all into one account. But okay, the question I suppose the trial court asked was, is it fair, because the contracts require commingling to some degree, is it fair to make First Financial trace? Okay, the legislature has answered that question, and per 1309.315, the answer is yes, they have to trace. There's no exception provided in the statute for, if it would be difficult, then they don't have to trace. Or if the defendant did something that they claim was untoward, they shouldn't have to trace. What the trial court did here was award over $1 million in damages against my client by basically just assuming, without First Financial Bank meeting its burden to prove, that even 1 cent, by First Financial's own admission, that even 1 cent came from receivables of Shining Knight or Wexford. Don't kid yourselves. First Financial absolutely could have traced. Okay, they could have. It's done in tons of cases.
I was curious how difficult that would be.
So it's done in other cases. They were requesting almost $1 million in attorney fees across all these cases. They most certainly could have traced. There are financial experts you use. Tracing comes up in divorce cases a lot. It comes up in a lot of contexts. And it's just an analysis that has to be undertaken. And we would submit that given what we know now, which neither the bank nor Tailored Fund knew about Harold Sosna and what he was doing with his check kiting and all the advances from other MCA companies, I would be willing to bet that if that analysis were undertaken, that it would basically disprove First Financial's case. But we don't have to guess about that because it was First Financial's burden. We argued it early on in the case, in the briefing. We had a damages trial. They had every opportunity to trace. I mean, we had thousands and thousands of pages disclosed in discovery. The bank accounts are even kept at First Financial Bank, some of them. So we would submit that the issue is very simple. First Financial did not trace. They didn't satisfy the tracing statute. The trial court erred by perplexingly just stating in the decision in one sentence the proceeds were identifiable and traced, when Tracy Farrell says, no, I can't identify even 1 cent of the transfers that I can specifically trace back to Wexford or Shining Knight's accounts receivable. So is my time up?
Your time is up.
Okay. All right, we would respectfully ask that this court reverse the trial court's decision. Thank you.
Thank you.